Now, Marie Schroff. Marie, of course, is well known because she was Secretary of the Cabinet and Clerk of the Executive Council for 16 years. What that tells you is she is a person of enormous discretion and judgment. But now she has moved over to be appointed as Privacy Commissioner. And that was in September 2003, and she's now been reappointed. So there's been a lot of high-profile privacy issues, and they are increasing. With social media and developments in IT. I think the role has never been more important as it is now, and of course the Minister of Justice, who was here this morning, announced quite recently that they would be implementing some parts of the Law Commission's reviews on the Privacy Act. So there will be reform to the Privacy Act. So Marie is going to come and talk to you about what she does and share the experience from the coalface. Thank you, Marie.
Thank you, May, and good afternoon, everyone. You've obviously been having a pretty intensive time, so I'm going to try and liven things up a bit by giving you an actual example rather than some theory. But first I just want to note quickly, and thank you, Charles, for giving me this segue into this, that we are not just a complaints body in the same way that, for example, the Commerce Commission is not just a complaints body. We're also a regulation-making body and a policy commentary body. So those functions are actually increasingly important, and I'm very pleased to say that for those of you who might think, how come you're making regulations? Well, the Regulations Review Committee stands ready to examine the quality of our work, and it certainly has done on occasion and made some suggestions for changes. So, as I say, we're not just a complaints body, but turning to the focus of May's book, which I think is very meritorious, which is to try and empower the people out there to use the various ways that you can influence, persuade, or even directly affect what government does. The Privacy Act is one of those underused acts, I'd have to say. There is a hugely important right inside the Privacy Act, which is that you have the right to access information about you throughout civil society, business and government. You have that right, and there are only few restraints on that right. And that right is not used as much as it should be. So if you take one thing away today, I suggest you think about that. There are lots of other rights in there, but that one is certainly one that empowers the public directly. So moving to my example, which illustrates what I've said quite strongly. We got a complaint recently about a chap wanting access to his information. So there's your access right. More than half our complaints are about access, and we get about 1,000 complaints a year plus about 10,000 telephone inquiries. So this is a normal situation for us, but this one has happened recently and I thought you'd be interested. It shows that we've got a way to go in how personal information gets managed, despite the Privacy Act having been in place for almost 20 years, and this is the sort of thing that could happen to any of us. So can we have the next slide, please? There had been a fire at the man's home and he'd made a claim. The insurance company engaged an investigator. They told him they had serious concerns about his claim, and they interviewed him and his wife twice. He then asked for his information from the insurance company. The insurer gave him an incomplete transcript of one of the interviews and nothing about the other interview. They repeatedly ignored his other requests and repeatedly refused him access to the investigator's report. Okay, so the insurer accepted the claim within about 3 months, though discussions about payments continued for a while. It took the man a further 6 months to get most of the information he'd asked for, now with our assistance, the Privacy Commissioner assistance. This included the investigator's report, which there had never been a good reason to refuse. And some information had been deleted along the way. Oh dear, your file has been routinely destroyed. The insurer never told him that he had a right to complain to us. He found that out from the internet. So this case actually went to the Human Rights Review Tribunal. For those of you who think that we do need these changes to our Act, yes we do, to cut through some of the processes, but in fact the Human Rights Review Tribunal stands there ready to back up our complainants when they have a genuine case. So the case went to the Human Rights Review Tribunal, and the tribunal, hot off the press, has just awarded him and his wife $10,000 compensation for the distress they suffered for being kept in the dark in a situation that was stressful and uncertain and where they felt they were suspected. So this is a brilliant demonstration of how to use your rights under the Privacy Act, and it can take place in almost any situation, whether it be a hospital or a business or a government department. The tribunal had some interesting things to say about where privacy rights sit in our lives, and with your permission I'm going to quote from this decision because I think it's so great. There's a new chair of the tribunal and he's doing some interesting things. He says, "The information privacy principles are not abstract concepts of little relevance to daily commercial life. They are in fact fundamentals of good administration and designed to reconcile the interests of the agency with those of the individual about whom the information is collected or held." Sounds pretty sensible, doesn't it? "Requests for access to personal information cannot be ignored or dismissed. Self-interest alone for the agency demands full good faith compliance with the Act. The benefits of such compliance include the individual being in a better position to understand and present his or her case. The benefit to the agency is that in turn it is better informed and more likely to arrive at a sound decision. The bottom line is that the Privacy Act is a two-way street." So I hope that case, I'm not going to say too much more, but could we have our next slide please? I hope that this case and this charming little slide, which I'll give you a moment to read, we've done a DNA test on the Guthrie and scheduled your baby's specialist appointments, court appearances and booked a prison cell. So, that's shorthand for, if I had an hour I could tell you all about it, but that's shorthand for the fact that personal information in a variety of settings, whether it be with the insurance company or with the hospital, the doctor, and even the course of your life, personal information is the currency of the 21st century. It has value now. It has administrative value and it has monetary value. And it has value as a means of control. In the right hands and in the wrong hands, information about us is valuable and powerful. At the same time, because of the technology revolution, it's becoming harder to know who's got our information, what they have, what they're doing with it, and how that could affect us. We probably can figure out what information our insurer will have about us, but what does Google or Facebook know about us? What does the health system know about us? So the Privacy Act is the key, folks. It's the key to unlock your rights and to help you get things right. The way that insurance example operates, you see the information is the key to unlocking the rights. So my job is to keep up with how we're collecting, using, securing and sharing personal information from finance, banks, insurance companies, e-commerce, health, electronic health records, GPs, hospitals, pharmacists, national collections, social media, mobile technologies, cloud computing, location tracking, targeted advertising, law enforcement, including effective targeting of organised crime, and to efficient, trusted delivery of public services. So what we have to do is help people to help themselves, turn them into digital citizens. That's what you're going to have to be in the future. That's what your children and grandchildren are going to have to be. They need knowledge and tools to manage their information in the way they want and to self-resolve. We can't be everywhere. We need to help people to self-resolve. We need to encourage business and government to get it right before they get it wrong. That's, almost like a mantra. Get it right at the systems level and at the training and the human level before you get it wrong and end up on the front pages the way the ACC recently did. And when things go wrong, I'm going to hold you to account for how you handle it. So the proposed Privacy Act reforms will beef up the protection for the 21st century. The proposal is to give me compliance powers and auditing powers and the like, so that I can get inside those computer systems or inside the administrative systems and say, get it right before you get it wrong. But those reforms will still let the Privacy Act be a two-way street, and they'll set us up for good administration in the next little while. So many people, I think, these days feel helpless to challenge big technology, big corporations, big government. Under the Privacy Act, individuals have important rights to keep control of their identity, and we're here to help you. Thank you very much.